All right, kia ora everyone, and welcome to today's Lunch and Learn at PMI New Zealand. Lovely to have you with us, whether you are joining live or watching the recording later. I'm Dr. Olga Lozova, the Women in Project Management Lead and the Auckland branch lead for PMI New Zealand, and I will be your host today. Just a quick bit of housekeeping before we get started. Please stay on mute during the session to minimize background noise. Feel free to pop your questions into the chat. We will answer them as we go along. And yes, this session is being recorded and the link will be shared afterwards. Now, I'm delighted to welcome our speakers from Wynyard Wood. Arthur Chung is director at Wynyard Wood and a highly experienced property and construction law specialist. He has worked across New Zealand and Southeast Asia for over 25 years and brings a wealth of insights on contracts, public works, and infrastructure law. Joining him is Pieter Winter, special counsel at Wynyard Wood. Pieter is a seasoned litigator with deep experience in building and insurance disputes and a broad international legal background spanning South Africa, Australia, and New Zealand. We are really lucky to have both of them with us today, so let's jump right in. Arthur and Pieter, over to you.
Thanks very much.
Morning, guys.
Thank you so much for joining us today. The focus of today's session really is to examine one of the main changes that have arisen with the latest revision of the NZ3910. And that is really the replacement of the engineer and his or her sidekick, the engineer's representative, with the contract administrator and the independent certifier. Now, I know there's been a lot of chat in the industry about what this means, whether it means a major change or whether it's a step change. And those are things we're going to examine today in this very much an overview discussion. We want to try and keep it pretty interactive. So if you've got any queries during our presentation, please fire them through in the question. I'll be looking at my screen, which I've got to the left of me, which will hopefully see any questions that pop up. So just in terms of our roadmap for today, I'm going to do a quick recap for everyone on the dual role of engineer in the NZS 3910 2013 revision. And if you're familiar, if you've been using this contract form since it first came out in '87, a lot of the things have remained sort of the same on a very high level. We'll then talk about the roles and how that role has changed by the introduction of the contract administrator and independent certifier. Finally, we're going to deal with some key observations from ourselves. We would say these observations are very early observations because we haven't seen major adoption of a 2023 revision to date. But these are what we've seen and what we anticipate may be the benefits and the challenges of this new form. So I'll just kick off and let's look at the dual role of engineer. Obviously, the first role is acting as the contract administrator, and in that capacity, really the engineer is the representative, an expert advisor to the principal, and in the circumstance of receiving progress payments and issuing payment schedules, he's acting as the agent of the.
Na mesma folder.
Então,
Só que é o formulário 014.
é diferente?
Okay, I'm just hearing some
Não,
other voices.
é esse formulário mesmo.
Excuse me,
Desculpa,
can you mute yourself? We can hear you. Please mute yourself.
Thank you.
There you go.
No worries.
That's all good.
Apologies for that.
Thanks. Look, on this slide, and I'm not intending to go through every item, but I'll just leave up on screen for you to look at. On this slide, I have put on what I understand to be the duties and roles performed by the engineer in his or her capacity as the principal's representative. And what you'll see, there's one item I've highlighted in red, is one item that can't be delegated to an engineer's representative. Obviously the second role that the engineer plays under the 2013 revision is to act independently, fairly, and impartially in making certain decisions, in valuing work, and issuing certificates under that contract. And on this slide, I've set out the duties that the engineer plays or has to carry out as the independent decision maker, valuer, or certifier. And again, I've highlighted in red on this particular slide those duties which cannot be delegated to the engineer's representative. Now, it's important to remember that's the default position. The contract does permit the engineer to further reduce the power of delegation by providing notice to the contractor, and that's in 6.3.3.
So when you look at
Pieter.
the inherent tension between the two roles, there are obvious tensions arising from the dual roles of the engineer, especially for those that are less experienced consultants taking on that role. And that is when things can get unstuck. The aspects affecting that would be wearing the two hats, the perceived bias and resolving disputes that come up when you are acting in the capacity. So when wearing the two hats, the dual roles can create inherent tensions for the engineer, particularly if the same person is both fronting discussions with the contractor as the principal's representative on a particular issue, and then having to make a determination later on that same issue. In practice, we often see the engineer appoint a colleague to be the engineer's representative to provide a degree of separation between the contract administration and independent certifier role to manage this. With a perceived bias, I don't know if you want to speak to that, Arthur.
Yeah, look, the perceived bias, I think it kind of arises from the fact that the principal is the one that's appointing the engineer. And whilst acting as a principal's representative, that's fine when you're asking the engineer to also perform duties independently, fairly, and impartially. That issue can arise. Appreciate that in the industry, most engineers will belong to a professional body, which will also require them to act in a professional manner. They'll be bounded by codes of ethics and codes of conduct, which the ones that I'm aware of do expressly deal with the need to act independently and impartially when given a role of certifier. So it's a perception out there. I think that there is bias. And sometimes I think where it becomes more real is probably when you're dealing more with inexperienced engineers being asked to make tough decisions. And particularly if you've got a principal who likes to throw their weight around and try and get the engineer to make decisions in their favor. And that's when we are kind of seeing that line being crossed. And when that happens, I think that's when this whole issue of being able to resolve disputes without having to refer to formal dispute resolution processes, including adjudication, which is supposed to be a quick fire resolution process. That's when those options are taken up by the contractor.
So while we acknowledge the inherent tensions of the dual roles, we consider the main issue with the 2013 and earlier revisions is the lack of clarity as to when an engineer is performing one role or the other. Which hats is he wearing? This issue is often compounded if the person appointed to the role is inexperienced. We think that's quite a focus to take away from that.
Yeah, so just to expand on that issue of lack of clarity, whilst in the previous slides that I put up, I've tried to separate out the duties in the 2013 revision to those where they're being performed by the principal, by the engineer as a principal's representative or expert advisor, and then separating them out from the independent certifier decision-making role. The problem with the contract, the way I see it, is that when you read through the provisions, it's not always clear. And obviously, at the crux of it is the fact that they refer to a single person. They refer to the engineer in all cases. And unless someone is very familiar with the conditions too, it's not always clear to the contracting parties what of those duties can actually be performed by the engineer's representative. So where there is both an engineer and an engineer's representative, that can certainly create some issues. And on this slide, I've outlined a couple of grey zones. I'm sure there are plenty out there, and would be more than happy to talk about some other ones that the audience might like to talk about. The ones that I see quite often, and I'm engaged, and so is Pieter, in terms of just looking at issues for principals and contractors, is around variations. Whether something constitutes a variation, and then how they might go about valuing them if parties decide or it's determined that a variation has occurred. The other issue that kind of crops up quite often is in relation to, and it's kind of tied to the variation issue, but it's where you've got ambiguities or correct omissions or errors in drawings and specifications, and particularly where you've got the engineer initially providing clarity or attempt to provide explanations in terms of those issues, and then maybe at some point in the future then having to make a determination on that issue if it remains in dispute. So if we kind of leave 2013 for a moment now, and given the issues that have arisen from that revision and the previous revisions, one of the core roles or one of the core changes in the 2023 revision, which has been brought about by the drafting team, is to separate out those two roles. So still a dual role, but now they're being performed by two distinct people in the contract, the contract administrator and the independent certifier. Now, they are both still appointed by the principal, and what is a noted change that I saw was that it now expressly says that the persons appointed to these roles have to be suitably experienced, and that's expressly stated in 6.1.1. Now, it's sort of implicit that that's required under the 2013 revision, because if you look in the specific conditions, it requires you to name the engineer as well as to put their qualifications in. But 2023 has taken that extra step to say that they are looking for someone who's suitably experienced. So you're looking, and that's going to be dependent on the project that the contract's being used for. The new 2023 conditions also seeks, in introducing these two roles, to really clarify who is performing what in the contract. So throughout the contract, you've now got these two new definitions, instructions and decisions. And what I'll be covering off in the next couple of slides is to just delve into that a little bit further. Now, like the 2013 revision and earlier revisions, these roles can still be performed by the same person. It does have to be a natural person. It can't be a firm, but the contract has preserved that ability. There are now new refined processes in terms of giving instructions and in reviewing and making decisions. And those are all kind of now set out in section 6 of the new conditions. There is the introduction of advisors in the new contract, and having removed the engineer's representative role have also disappeared. Now, if we look just a kind of an overview of what the contract administrator's role is in the 2023, you can imagine all the things that I previously said that the contractor, that the engineer did as a principal's representative. All of those duties have actually been carried over. But now, instead of seeing the word engineer, you're actually going to specifically see the word contract administrator. So that's one of the I think the good points of the latest revision. So going through the slide, you can see CA fulfills all the roles previously held by the engineer in the capacity as a principal's representative, expert advisor. Acts for and on behalf of the principal in giving instructions to the contractor. All instructions shall only be given by the contract administrator with a copy to the principal and to the independent certifier. Instructions have to be in writing or to be given as soon as reasonably practical thereafter, and they do need to indicate whether or not they're a variation. Now, you'll notice that a lot of the stuff isn't too different from the 2013 revision. Instructions given by the CA to the contractor bind both the contractor and the principal, but there is the ability to reverse or vary those instructions in accordance with the contract. And the other thing that is made clear in this revision is that the contract administrator kind of takes on that primary role of trying to reach agreement with the contractor whenever there are matters under the contract that there requires agreement, that are in dispute. That's not always the case on everything, but most things in this contract, that's the contract administrator's role to do. And the independent certifier plays a role in kind of making a decision or final decision if that matter can't be resolved between the parties. So if we look at the independent certifier role, the role of the independent certifier, again, is not too dissimilar to the role of the engineer under 2013 when requiring to make decisions, when requiring to value work or issuing certificates. But the clarity that's given in the new contract is that you know exactly when it is the independent certifier actually carrying out that duty or not. The independent certifier is also the this is the one area which has been preserved. The independent certifier does act as a principal's authorized agent when receiving payment claims, incorporating the principal's deductions of payment schedules, and when issuing payment schedules. There is a new process for the principal or contractor to request the independent certifier to make a decision or final decision, and they can receive input from an agreed expert where necessary. That's set out in 6.4. That is a process which kind of keeps everything within the sphere of the two parties and having the independent certifier kind of playing a role in trying to make a decision. The independent certifier's decision, including his final decision, does not preclude other dispute resolution processes in terms of like adjudication, or if either party wants to refer a matter to section 13 of the contract, which is a formal dispute resolution process. There is that step-through mechanism of having senior executives get together and try and resolve any disputes between them. There's the option to refer the matter to mediation, and ultimately, if those if those dispute resolution processes cannot result in an agreement, either party can still refer the matter to arbitration. Now, the role of the principal advisors, I'll just let Pieter speak a little bit about that.
So we know the principal may engage advisors to advise the certifier or the administrator in carrying out of the duties, including making submissions and recommendations to the administrator or the certifier, or providing other assistance and support. Advisors have no authority, obviously, to issue instructions or make decisions. And the administrator and the certifier are responsible for notifying the contractor of persons appointed as advisor, and also when such appointments cease. And we think what's really nice about this is it creates further clarity where new people are appointed going forward and some people are left behind. We think the duty to advise the contractor in writing of the appointed advisor, or if any advisor is no longer appointed, which is new, it provides the clarity because all the players are identified that may be engaged at any time. So everybody's pretty much on the same page. There will also be the usual advisors, such as the design team members, quantity surveyors, and lawyers. And where it may become quite interesting is if a particular dispute is brewing, particularly around workmanship or delays, the principal is required to engage specialist advisors, such as delay experts or litigation lawyers. 6.3.6 seems to require the administrator and certifier to inform the contractor of such appointments. Now, we anticipate that in practice, this notification requirement is probably a positive step, as it would take away any element of surprise. And in most instances, the engagement of specialist advisors will not be unexpected, as the issue at hand will have mostly likely been a focus of discussion between the relevant parties.
Just to add to that, that requirement is new because there was never an express provision dealing with advisors or role of advisors. That said, it's not uncommon for the previous revision to be amended to refer to specific roles. And I think the most common one is probably the QS. For that one in particular, when you're involving a large funder who wants QS oversight and sign off on all things relating to the contract. So in terms of kind of key observations at this stage, we do think it's early days, but we really think for time being anyway, I think there are a lot of people out there. The industry is still continuing to be sticking with what they're familiar with. So I still see a lot of use of a 2013 revision. And given that, the industry is using tried and tested methods of dealing with the inherent tensions and the clarity or the lack of clarity of that revision through the way that they practice and through special conditions added to the contract. I do think that the new role and the definitions introduced in the 2023 revision were good ones. I think they're very positive change. And I think it will hopefully address a lack of clarity for some in the industry, particularly those who are only just starting to use the contract and not familiar with its form and the duties to be performed there. Now, whilst the 2023 revision does permit the same person to perform both the CA and the IC role, I think in practice we would still think that the best practice would be to have different persons to carry out that role, and I think that will certainly help removing some of those inherent tensions and any perceived bias that we talked about before. I mean, what we tend to see happen anyway, currently in the 2013 revision, is that there is some degree of separation because you've got the role of engineer and you've got the role of the engineer's representative. And typically what we see for most projects is the engineer will be someone who's appointed in the project management firm, who is a director, a senior person, a wise head of the organization. And they will nominate someone within that firm, usually a senior or intermediate colleague, who will actually do all of the day-to-day contract administration duties. So that practice that's occurring already is something I think would be something to retain, moving to a 2023 role. I think what really will be interesting to see, and again, I'll be interested to see what the audience say about it, is whether there might be a move with the possibility of having two different people assigned to these two different roles, whether you're going to have the advent or the or new firms kind of or new professions actually coming out which kind of specialize in the contract administration only and the IC roles. I think that probably ultimately that might be best practice. But there will obviously be issues around whether that is the most cost-effective and efficient way to manage contracts. And I think this is going to be a moving space because with in this day of digital storage, digital compilation, editing of documents, and all the tools out there for managing communications, and also with new AI tools that may possibly come out, it might well be much easier for separate people from separate firms actually working together to be able to manage a contract, adopting these two separate roles. So this is something where we'll be interested to see what happens. I think ultimately under the old contract and under the new contract, the key thing will be around engaging the right person for the job, someone who's going to be competent, is going to have experience in dealing with both roles or either role under this new contract. Because where we have often seen things and when things are going well, we don't typically see them. A lot of contracts do not get the lawyers involved to review and to prepare. We typically get involved at the when things are starting to go wrong. So from our experience, really it sort of comes down to I found engineers kind of probably not acting as doing their job as well as they could in picking things up early and using the advanced warning or advanced notification provisions in the contract, getting confused around whether they're acting as the principal's representative or as the independent certifier when they're carrying out their duties. I think that's where the issues have arisen. So I think that the clarity that's been brought about by this revision and the express requirement that you need to engage a suitably experienced person, I think that will hopefully resolve some of those issues that we see.
Yeah, particularly like from a litigation point of view, right? Clarity is good. As soon as it becomes blurred or grey, that's when the lawyers get involved, and if you can avoid that, so that's usually a good thing. People can resort to other dispute resolutions and sort it out, and then if we have to come in to deal with stuff on that level, then we'll have to deal with it. But if the clarity is there, it assists everybody, and we think this 2023 revision definitely brings more clarity.
Yeah, and I think Pieter and I were discussing this while preparing the presentation. We don't, in our view at this stage anyway, we don't see the splitting of the roles as having sort of any material impact on how professional indemnity and liability issues how they may be reflected in the contracts. I think the introduction of these two distinct roles does give an opportunity, particularly for designers, and I'm speaking probably to the architects, who do take on both a design role for the principal, usually pre-construction contract, and then tacking on to that the contract administration role. Whilst in most instances there might not be issues of conflict, the area of conflict that we do sometimes see is when there is some error, omission, ambiguity, or issues arising from the documents that the architect's prepared or the architect has overseen in terms of a team of design consultants. And at that point, it becomes fairly grey, depending on the circumstances, whether the architect should retain that ability to be the certifier and to be the decision maker when dealing with those particular kind of issues. We would think in those kind of situations, yeah, you should be taking advice. You should be looking at how, whether there is a conflict of interest that has arisen, and you might need to step aside. Now, I don't know the makeup of this audience, but I don't think it typically affects any other of the. I don't think it will affect like the dedicated or professional project managers. I think we principally see it when designers take on that engineer's role. So under this new revision, we could see the designer still retaining a contract administration role, but might be best practice moving forward to step aside from the independent certifier role. So, what are the next steps? I think for those who have yet to do a deep dive or do a contract with the new revision, I'd say don't be scared of it. I think it's been a very positive move, and I think when you read it, you will see that a lot of things haven't actually changed. There's been some degree of refinement in certain areas, and certainly won't have a time to kind of do a deep dive in all the changes. But overall, there hasn't been any material step changes to the general conditions. The major change is giving that clarity around when the principal's rep is actually acting as a contract administrator, or when they're actually doing the independent certifying role. And I think that is what we've been talking about today. If you are interested, I did see that LexisNexis do provide a free checklist. It's a one pager. It provides a download, and you can download it. It provides it lists 13 key changes made to 2023 revision. If you want a quick reference to give you those changes. And I think for the industry, those who still like special conditions, there's still a place for them, because when this revision was being revised, or when it was formulated, I think there was clear message from the industry, but from both principals and from contractors, that they didn't want to change. They didn't want to change everything. There were a lot of things that have kind of been adopted by either side that weren't brought into this particular revision. I would, however, suggest that for special conditions, they should. I think more care should be taken in using them. I think the general conditions as they stand with the specific conditions and with the guidelines that are provided with this revision, as was with the previous revision, I think there's actually 90% of projects probably can be used quite well with the general conditions. The key aspect, I think, from my experience, is making sure all the other contract documents are done well, put together in the pack when you're putting together the contract, and to the extent possible, trying to address any inconsistencies or omissions at the time of contracting. There's a lot of provisions that I see in special conditions is really trying to protect primarily the principal and the consulting team from inconsistencies, from errors, from mistakes, and trying to put that risk on the contractor to identify them as during that tender process. I think I don't know whether the industry is going to change from that kind of practice, but ultimately, what I see is contractors are going to obviously price for that risk. If you're going to put that risk on them, that's what they're going to do. So, my own personal thoughts, based on kind of 30 years of working in the construction industry and 30 years of using different revisions of this contract, I tend to try and push clients when I have a say to using the contract as it is, and if I'm going to be using special conditions, to take a more light or project specific or client specific approach to preparing them. It is going to be a challenge, I think, for the industry, because a lot of the special conditions that do come through, a lot of them have genesis in government projects, where governments, where the different ministries have insisted on taking certain positions around risk, and those special conditions are then permeated into the private sector. So it'll be interesting to see whether this new revision, and with technology and with AI, is going to change those kind of practices. We don't think that there has been a major change, so I think a lot of the things that you're doing now, if they work well under the current revision, I think they will work well under the new revision. Yeah, so it is early days, and for me personally, I can count on one hand how many projects I've had to look at the 2023 revision, whereas 2013 still remains the most common form being used right now. So,
questions?
Just some questions there. Chris has asked, in the scenario where the IC and CA are appointed to separate entities, when a CA is not performing the duties of man expected, to what extent is the IC empowered to intervene? Or does that rest with the principal's advisors? The IC, well, the CA role, the CA does not answer to the IC. The IC has certain roles, and usually IC is there to make decisions and value and certify when those duties arise. Now, if a CA is not performing, then most likely the CA is going to be in breach of its obligations under the contract. And given the CA is acting for the principal, it then arguably it becomes a bit of a principal default when that happens. The IC may have a role if a contractor is raising an issue to the IC. But that would be my answer to that query. If you have a specific scenario, please let me know. Just looking at the second question.
From Pieter Johnson. Seen a large organizations with their own engineering teams nominate a staff engineer to be the engineer to the contract under 2013. In future, will they be expected to appoint an outside contractors to the independent certifier, to be the independent certifier?
Yeah.
That's right.
Look, that's a good question. I think
I'm just going to set up some payment.
Yeah.
Again, sorry for that.
no, that's okay. Look, I think with the the independent certifier role ideally should be someone outside the organization. If you want to address the inherent tensions, the bias issues that we've identified, it's sort of you're not taking the full advantage of this new contract if you're going to continue to retain that in-house. The other question, I guess, is with that particular one, whether it might have some issues around mistrust, whether the contractor is going to then end up pricing for the risk, and whether there's going to be more of a reference to formal dispute resolution processes rather than relying on the independent certifier to make those kind of decisions. I don't think that the new revision precludes the use of someone in-house, but I wouldn't say that I would be supporting that kind of practice.
Yeah, the conflict of interest goes a bit of a way if you do that, right? If you spread it off.
Yeah.
So that's a good thing.
Were there any other queries? Oh, that's a good question. What qualification experience required for a contract administrator and independent certifier? I think that will be project specific. I would have thought, but for the independent certifier, I think that's probably gonna be the higher. That's a more important role given the need for independence, the need to act fairly and impartially. So I would think it would. I think it would depend on the project, the scale, and yeah, the value of a project. Is the intention of the 2023 version to align with NEC when it comes to dispute resolution? Look, that's a good question, and I'll have to be honest, I can't answer that, because we haven't actually had that much experience with the NEC contract in New Zealand.
Yeah.
However, if you've got Catherine, if you've got a specific query around that, I'm happy for you to get in touch with us separately, and we can have a look at it.
Yeah, it's an interesting question.
Yeah.
How does the role of the independent certifier affect payment schedules and the dispute resolution under the 23 update?
It doesn't really. There is the independent certifier role is not too dissimilar when it comes to dealing with payment claims and payment schedules. However, it's in the new revision, it's identifying it by that role rather than referring to the engineer. In terms of dispute resolution has changed in the 2023 update. There is now, I'm going to refer to my old firm, Chapman Tripp. I know that Edward Scorgie has actually and his team have done a really nice summary of the dispute resolution process.
That's in 13, right?
Comparison between the 2013 and 2023. I'd be happy to send a link to you to have a look at that one, to look at the differences in dispute resolution processes.
given the decoupling of the engineer's dual role, how do we best structure the relationship between the principal's representative and the independent certifier to avoid authority overlap or ambiguity in contract execution?
Okay, so look, in terms of that question, when we talk about contract execution, I assume it's not about signing the contract. I assume you're talking about administering the contract. The relationship itself will still be an engagement, I would have thought, between the principal and the consultant that's being engaged to take on those roles, the contract administrator role and the independent certifier role. Then it will be a matter of defining those terms and the scope of engagement, and that will be, I think it will be clearer, in fact, particularly if you're engaging separate people to take on those roles. If you're engaging the same firm, it might be needing to identify who the actual personnel will be in carrying out those two roles in the new contract, and ensuring that that it is those people that are carrying out those duties under the new contract terms. It did make me recall that I should be making this point, that probably one practice that hopefully will become a natural thing that you would do under this new revision is to ensure that when you're sending communications that you are using the new defined terms. So clearly saying whether it's an instruction, whether it's a decision being made, clearly stating whether you are making it as a contract administrator or as an independent certifier, referencing the clauses in the contract when doing so. But there should be no more confusion, if done right, as to whether you are performing in one role or the other, because the contract doesn't mix the two.
So that's it.
Thank you so much. Do we have any other questions? Just remember, there are no silly questions. You can ask any question today. We do have two experts, not just one expert in the room. So please ask your questions. The most important question is, will the presentation document be shared after the session? Yes.
Absolutely.
So, yeah.
It will be sent out.
Yes, no problem. And I'll provide with that some links to articles that we had a look at too in preparing this that we think might be helpful. There's plenty of information out there.
Yeah, it will be greatly appreciated.
But I think nothing is a substitute from actually reading the contract. It is a big whopping document, though.
Yeah. All right. Any other questions? Do we have any questions from anyone? No, it looks like no more questions. Pieter, Arthur, would you like to add anything else to your presentation?
I don't think there's anything more. We just still think the clarity is welcome, and knowing which hat a person who's wearing is really, really good. A step going forward. It's just to change the mindset and starting to use the 23 revision. That's the big step to get to.
Yeah, look, and I think if the concern is using the contract in its form unamended, because I know there are a lot of special conditions out there, different versions that everyone's comfortable with and are familiar with. I think take that step. Either review it yourself or have someone else review those special conditions. Some of them will still remain very applicable because there hasn't been massive changes to certain parts of a contract. But I guess the challenge I have to the industry is primarily going to be, are those special conditions in most circumstances needed? One example that I often come across is we as lawyers are asked to deal with lots of issues by way of special conditions, and then later on in the process we will see there is a preliminary and general specification document that might come through, and it actually covers a lot of the things that we're asked to put into the contract. And that's one of those kind of scenarios that you can inadvertently introduce inconsistencies as to what you're expecting from the contractor. So I think it's good to talk up front, have everyone around the table who's going to be preparing parts of the contract documents, to understand where the overlaps lie, and to the extent you can eliminate those overlaps.
All right, thank you so much. And plenty of thanks from our attendees. So thank you all for joining us today. A big thank you to our speakers for sharing their insights, and to all of you for your time and great questions. I'll be sending out a follow-up email shortly with the link to the recorded session and the presentation, as well as details on our upcoming July session. So keep an eye on your inbox. Enjoy the rest of your day, and we hope to see you again soon.
Thank you. Thank you for
Thank
the
you so
opportunity.
much. Thank you.
Thanks all.